The courts should be transparent. And generally speaking, the press should be allowed to report what happens in our courts. And so this is an anomaly that these things were filed under seal.
President Bill Clinton is the most famous person thought to be on a list of almost 200 names linked to the Jeffrey Epstein, Ghislaine Maxwell sex trafficking conspiracy. Those names could well be released today. Well, David Katz is the former Assistant District U.S. Attorney and Beverly Hills lawyer, and he joins us now. Good morning.
It's great to be with you. I was an Assistant U.S. Attorney, we call it here.
Yes, brilliant to have you. Thank you so much for joining us. It's obviously very early here and we appreciate your time. For people who haven't been following this story as closely as you will have been, what is this list that we're talking about, these 200 odd names?
Well, there was litigation that was brought by Ms. Giuffre, and she was trying to sue, and she did sue. Ultimately, she settled her case. In the course of settling the case, there was a lot of discovery. There were a lot of things that were placed under seal as part of the submissions by the lawyers. There have been about 7 rounds of disclosures of the information that was filed under seal. And what's about to happen now after January 1st is that there's going to be an 8th, and people think just about final unsealing. And it will have all of these, it will name names, and it will also go into detail about some of the already named names. However, at the same time, people think it won't really have that many bombshells because most of the people associated with the case have already been mentioned, either because they've been interviewed or because they've made public statements, for example, denying allegations in the case. But at the same time, of course, it's just such a high-profile case, and the people involved, Prince Andrew, former President Clinton, billionaires, very prominent people. And so everyone's kind of holding their breath, but at the same time, some of these things, it may not be as explosive as people think, but still people are holding their breath. Apparently, there's been a period of time that people mentioned in there have been allowed to object to the disclosures and say, please don't disclose this information about me. It's been reported that former President Clinton has not made such an objection. So presumably there's not much in there new that hurts him, or else he would have fought to have it not disclosed. At the same time, if President Clinton was anything, he was very, very smart. He was an attorney himself. He may have thought, you know what, just let it come in. Don't look like it came in over my objection.
I mean, you mentioned Bill Clinton there. There are obviously, I mean, he is an incredibly high profile name. And as you say, has been sort of widely reported to be on this list. Who else do we think might well be named?
Well, I don't want to go into that. I think people are shamed enough by these things. You know, at this point, apparently, there's no civil liability. There have been some cases that were reopened. There are these statutes that allowed a window for people to file civil claims. But apparently, these disclosures will not produce civil charges, civil claims. They won't produce criminal charges. As I say, they will name and shame some people, and they may go into more detail about people. But I just don't feel like it's my place, to engage in that sort of naming and shaming. If there were some suit or criminal prosecution, I'd be happy to say who it was against.
I mean, that's a good point, isn't it? If there's no civil suit here, or there's no sort of legal repercussions for most of the people on this list, and there is a very real risk that they could be branded guilty just by being in this list of names, why are they actually being released?
Well, because we have a concept in this country, I think you have it in Britain too, of government in the sunshine, that the courts should be transparent. And generally speaking, the press should be allowed to report what happens in our courts. And so this is an anomaly that these things were filed under seal. Obviously, there are privacy interests that counterbalance the government and public interest in something being disclosed. And so the court has decided previously over the last few years not to disclose these particular portions. And now the court is basically saying, I think, to go back to the norm being public disclosure and let people read what happened in the courts. Let me give you an example, if I can. Apparently, this is going to disclose that they tried to depose Bill Clinton. Bill Clinton's lawyers around 2016 or 2017, that's just about when Hillary was going to run or was just nominated for the Democratic, to run against Trump in 2016. former President Clinton resisted the subpoena, resisted being deposed. He eventually won in front of the district judge. The district judge said that it was irrelevant, that there was nothing that he could really add to this. Now, the backstory to that is that Giuffre claimed that Clinton was on this so-called sex island of Jeffrey Epstein. Clinton, through his spokesperson, said no, he was not. His deposition was not taken, however, because the judge ruled that that was irrelevant to the claim that was being made, and then there was never a final ruling on it because the case settled. Now, those details are juicy to read about. I just mentioned them because I think they're interesting to people, but at the same time, kind of, where does that go? What does that really lead to legally?
Yeah, it's a complex picture, and I'm sure it won't be a comfortable day for many people on that list, despite what you say about the lack of legal repercussions, perhaps. David Katz, a former Assistant District US Attorney, thank you so much for joining us this morning.